Recognizes the gentleman from Maryland.
And thank you, Mr. Chairman. I want to start by saying I appreciate what you said, Attorney General Bondi, and you said it to me personally, that you take the personal security of every member of Congress seriously and that people can contact you about that. And in these times, that's a very serious matter. So I thank you for that. Article 2, Section 1, Clause 7 of the Constitution is the Domestic Emoluments Clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn, but he wants $10 billion. Now, I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
You're obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this, because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it. And if you go off on a wild goose chase, another tangent, you start reading statistics or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today. Okay, so, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them. The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing you.
Shame on you.
The time of the gentleman has expired. I would remind the committee that last Congress, Secretary Mayorkas was here numerous times, and he wouldn't answer our questions, even when we sent them to him ahead of time in writing. So that's what we've had to deal with. I think the Attorney General is doing just fine. We have votes shortly. I will go to the gentleman from Virginia.
This exchange is far more than a routine hearing. It is a revealing snapshot of a deeper crisis in accountability, discipline, and respect for institutional norms. When an Attorney General is unable or unwilling to provide direct, substantive answers to core legal questions, and instead pivots to personal attacks, deflection, and rhetorical distractions, the damage extends beyond individual credibility. It signals a breakdown in the very standards that are supposed to govern the highest levels of law enforcement. Questions grounded in constitutional limits, privacy rights, and the protection of victims are not political talking points. They are foundational responsibilities. When those questions are met with evasion rather than clarity, it raises serious concerns about whether the rule of law is being upheld or selectively interpreted. Even more troubling is the broader implication of what this moment represents. It reveals a system where power increasingly operates without immediate consequence, where procedural rules can be brushed aside, and where accountability becomes negotiable rather than mandatory. In such an environment, the law risks being reshaped into an instrument of political convenience rather than a neutral framework of justice. The inability, or refusal, to engage directly with oversight not only undermines the authority of Congress, but also weakens public confidence in institutions meant to protect fairness and transparency. When oversight turns into confrontation, and answers are replaced with diversion, the gap between authority and responsibility widens in plain sight. Ultimately, this is not just about one official or one hearing. It reflects a broader erosion of institutional integrity. A functioning democracy depends on the willingness of those in power to submit to scrutiny, to answer difficult questions, and to operate within clearly defined limits. When those expectations are ignored even momentarily, it sets a precedent that accountability is optional. And once that precedent takes hold, the consequences are far-reaching. Trust declines, standards slip, and the distinction between lawful governance and unchecked authority becomes dangerously blurred.